We will now take up Matthew Schrader on the record now in 2025 TR 1342, State of Kansas versus Matthew Kyle Schrader. Jared Regier for the state. Mr. Schrader, do you appear?
I'm here in pro persona sui juris, appearing specially and not generally, and I reserve all my rights, remedies, and objections.
All right. So I find the defendant does appear personally, and Mr. Regier, his charges and penalties, please.
Your Honor, pursuant to the information filed with the court on June 13th of this year, this is a case that appears to involve two charges. Count 1, failed to register a vehicle and classified non-person misdemeanor. Count 2, no proof of insurance, a class B non-person misdemeanor.
And you said these were allegedly committed when? Which state, according to the document?
Your Honor, the charging language in counts 1 and 2 appear to allege occurrence dates on May 21st of this year.
And location within Butler County?
That appears accurate, Your Honor.
Okay. All right, Mr. Schrader, can you still hear me okay?
Yes, I can.
All right, I'm having some issues here, as you can see. In count 1, failure to register a vehicle is an unclassified misdemeanor. It carries its own special penalties of a fine up to $2,500 and a potential sentence of 30 days up to 6 months, although probation is an option and time to pay is an option. And no proof of insurance is a B misdemeanor. That carries a fine of at least $300 up to $1,000 and a possible jail sentence up to 6 months. Now, you do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. Because there is the potential for 6 months jail, you would most likely be appointed an attorney if you qualify for court appointed and cannot afford to pay on your own. On the issue of attorney, do you intend to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself, sir?
I will waive my right and present myself.
All right. Is anyone making you waive your right to an attorney today by any threats or promises?
No.
Or any other reason?
No.
All right. And you do understand, for the record, that you do have the right to hire or apply for court appointed if you cannot afford to hire. Do you understand that?
Yes, I'm aware of that.
All right. I will have the record reflect then that you are knowingly and voluntarily waiving your right to an attorney. You're also exercising your right to represent yourself. I'll have the record reflect that in the docket notes and the journal entry. Now then, let's go through these charges. Count 1, fail to register a vehicle. How do you wish to plead to that? You can plead guilty, and that admits it, and we would proceed to sentencing. You could plead not guilty, denying the charge, and we would set it for trial at a later date. Or the third choice, no contest, means you don't want to admit these charges, but you don't want to admit them, but you don't want to go to trial either. So you'd be pleading no contest. We'd still find you guilty without trial and proceed to sentencing today. Another might be, it's not a plea, but another option might be diversion. The county attorney would offer you diversion if you qualified. You'd have to go online, as I've said several times today to others. You'd have to apply and see if you qualify. They'd send you a response within the next couple of weeks in the U.S. mail. If you agreed to the diversion terms, you would sign the contract and send it back. And if you did everything you were agreeing to, they would dismiss the charge or charges against you, charges if they're both diverted. So, but do you want to divert or apply for diversion? I'm not going to say you get it. I don't know your history, and that would come into play. But how do you want to proceed on the issue of diversion or plea?
Okay, so before we get to that, on the record, I've recently served a subpoena to the sheriff's office for records relevant to my defense, and the sheriff's office has filed a motion to quash that subpoena. So today, I'm respectfully asking the court to schedule a motions hearing so that we can resolve the sheriff's office office's motion to quash, and that I be allowed the opportunity to pursue negotiations.
All right, you have filed a written motion for subpoena of what document?
There is and
So you-
typical things like and camera footage.
and they have filed a motion to respond. It's part of what you requested. Destiny, do you have out there in front?
Um, Sheriff's Office quash.
Are those necessary? You want to plead before?
Well, I feel like it'd be appropriate to till get evidence and able to be formed to enough to make an appropriate plea.
All right, so you're telling me you don't want to plead not guilty today, you don't want to plead anything today, is that what you're saying?
Right.
Well, you understand this is the hearing that happens, we enter a plea at first appearance. That determines what happens from there. But if you're refusing to enter a plea, and based on what you've told me, I am going to enter a not guilty plea on your behalf, and we can set this for motions hearing prior to a trial date. So how much time, sir, do you think this motion hearing is going to last? Well, I don't know how much time to reserve on my docket.
Are you asking me
I'm asking you, sir.
how much time I need?
No, I mean, how much time the whole hearing will, you anticipate will be?
20 to 30 minutes.
All right, let's be safe. Mr. Regier, have you seen these documents he's referring to?
I have, Your Honor, and what I would tell the court is it would appear that on or about the same time that the written objection to defendant's subpoena dulcis tecum in motion to quash was filed with the court, an entry of appearance was also filed with the court by Mr. Terrence Hulskamp, the Butler County Counselor.
And Mr. Hulskamp entered on behalf of the sheriff's office, apparently. Did he file the response?
That would appear accurate, Your Honor, based off of the information in this before the state.
All right, so it sounds like he'll be the one that will be responding to that rather than you, perhaps, just to that limited issue, or do you know?
Be filed by Mr. Hulskamp, Your Honor.
All right, let's set a motion hearing on a Wednesday afternoon. Destiny, what do you have available? Somewhere, I would say maybe an hour at the most. And I know that's a lot on the docket because we have so many other things going on, but
And you do want it on an afternoon, Your Honor?
yes, I think so.
We can put it on with the bench trial dockets and still label it as the motion, and we can block off the rest of that day.
What are you
November.
looking at? I'm sorry, I talked over November what?
Nope, you're okay, Your Honor. November 12th at 1:30.
All right, well, that all sounds good. Okay, I'm ordering defendant to reappear for motion hearing on the bench trial docket, November 12th at 1:30. That will be by Zoom. And I trust counsel for the state will, of course, let all of their attorneys know that need to be here. All right, so that's where we are. And then if we decide we need a trial date, I'll set it at that time, Mr. Schrader. Do you understand that?
Yep, sounds good to me.
All right, if there's nothing further, let's see.
Your
We
Honor,
don't-
there are multiple matters still to address.
Go ahead, please.
Your Honor, as given the statements made on the record today, the state is requesting a ruling by the court as to whether or not this motions hearing is being set, requested, and this matter is being set over by the defense.
Speedy trial time does count towards the defense if he is asking for this motion hearing to be set and that it be done before trial. And
Okay.
because he did not enter a plea today, I had to enter one for him. So I will definitely count the time against the defendant.
Thank you, Your Honor. Secondly, this is a defendant who seemingly appears pursuant to the summons, so it would appear that the issue of booking as required by statute, specifically pursuant to KSA 21-2501 section B, is outstanding. The state does have certain special recommendations concerning bond in this case. While the state is not opposed to the court ordering an unrecognizance bond, given that the defendant has seemingly appeared pursuant to a summons, the state, in light of statements made on the record, is requesting a higher bond in this case, at the very least $3,000.
Anything you want to say about your bond, Mr. Schrader, before I declare it?
I object to that since I appeared here as I was supposed to.
All right. At this time, bond is set. You said how much, Mr. Regier, based on that?
$3,000 was the state's recommendation, Your Honor.
I will adopt that recommendation. Mr. Schrader, you are ordered to appear at the time given by the officers for booking and processing. Your bond will be set at a 3,000 OR. That means you don't have to put up any money unless you fail to come to court at a later date. But if you fail to come to court, you may be determined to owe $3,000 to the state of Kansas on your bond. So look for the breakout room that says, it'll come up on your screen, invitation to a breakout room, and you'll go in with Deputy in Court Security 2 and set up a date and time. Now, if you fail to follow that order and show up at the date and the time the officer gives you and post a 3,000 OR bond, then I very well may have to issue warrants for you. But right now, because you did appear when you were told, I'm going to make it OR, meaning you don't have to put the money up front. You understand that or have any questions about that, Mr. Schrader?
I think I understand it.
Oh, very well. Look for that invitation on the breakout screen. And Destiny, if you'll put that on there for Mr. Schrader, for the officer in Court Security 2.
What time? So it's November 12th?
The motions hearing is November 12th at 1:30, correct?
1:30. Okay.
All right. So please accept that breakout room, Deputy. Are you available for that?
I am.
All right, thank you. So Destin, if you'll just put the two of them in a breakout room. Okay, anyone else that you want me to address that I haven't yet, Destiny?
I have no others on my list, Your Honor. Just like I said, it does seem that Mr. Matthew Schrader is still on the hearing with us, so I didn't know if he needed anything else from the court after his hearing.
Let's look at that again. On the record again in BU 2025 TR 434, State of Kansas versus Matthew Kyle Schrader. Jared Regier still for the state. Mr. Schrader still on the docket after being excused.
I didn't hear a recess.
I'm sorry, what?
I just didn't hear that I was given recess.
Okay, I'm sorry you've had to wait this long then, but I am releasing you at this time as you did have your motion hearing set. 11/12 at 1:30.
Yeah.
All right, you may go, sir. Thank you.
All right. Thanks.
You're welcome. Now, anyone else? Destiny, anyone else that we skimmed past or skipped?
Not that I have, Your Honor. I'm not sure what Mr. Regier's list shows.
All right, Mr. Regier, do you have anyone else?
Nothing further from the state, Your Honor.
All right. Well, this docket is adjourned, and I see we have some in the afternoon. I'm going to try to get my health in order here and maybe even get my computer in better working order too. So thank you all for your tolerance this morning. We are adjourned for this morning.
Well, there you have it. I don't know what you guys saw. I don't know what the internet issue is. Thanks to Brecken for getting that to me. It was pretty good, but my screen was clicking off and everyone was saying they couldn't hear. So I'll probably delete that one, which is too bad because because it was fun. We had Regier and a dopey SovCit who marches in there and starts out with, I'd like to set a hearing date on their motion. Well, okay. Usually that happens when the motion's filed already. He just thought he was really clever because he thought he had caught them because he's like, they filed a motion to quash. Oh, and so they did. And they sent you notice of it. That's not like you didn't do any detective work to figure that out. When they file a motion, they have to serve you with it. like he expected the judge to be shocked about it. Like, oh my God, no. You're saying that the other party filed a reasonable motion that serves their interest? I'm shocked. I can't believe it. I've never seen such a thing before. Oh, that's good times. I want to see this guy get into it a little bit more. He seems pretty earnest about this. I think he's got potential to make us all laugh. Thanks for coming out. I appreciate it.